The playground was supposed to be the safest place in the neighborhood. Bright slides. Soft rubber ground. Laughter in the air. So when my phone rang and a stranger whispered, "Sir, your daughter can't move her arms," my first thought wasn't anger. It was disbelief. Because no parent expects a playground, of all places, to become the beginning of a criminal case. My daughter, Sarah, was 8 years old. She had a physical disability that limited her balance and coordination, but it never limited her spirit. She loved the playground. Not because she could do everything, but because she could do enough. That morning, she wore her blue jacket zipped all the way up and a smile she practiced in the mirror. Her adaptive braces clicked softly as she walked. She held my hand a little tighter than usual. "Daddy," she said, "today I'm going on the swing by myself." I smiled. "I'll be right there." The playground sat inside a residential complex managed by an HOA that liked to remind everyone it was in charge. Too much in charge. People didn't call her Karen to her face. They called her that in texts, whispers, and warning looks. She was the HOA's community compliance officer, a title she wore like armor. Clipboard always tucked under her arm. Rules memorized. Empathy absent. She'd yelled at kids for chalk drawings. Threatened parents over picnic noise. Once told a disabled veteran he was lowering the community's image. Complaints were made. Nothing ever happened. Until that day. Sarah headed toward the adaptive swing, one designed specifically for children with disabilities. Karen noticed immediately. She always noticed. I saw her from across the playground, marching toward the swing set like she owned the air around it. She stopped the swing mid-motion. "This equipment is for approved use only," she said sharply. Sarah froze. I am approved," my daughter replied softly. Karen looked her up and down. "Where's your caregiver?" I stepped forward. "I'm right here." Karen didn't look at me. She looked at the swing. This playground has rules. Liability rules. Parents nearby went quiet. Kids stopped laughing. The joy drained out of the place. Sarah tried to step down carefully, just as she'd been taught. But Karen reached out, not to help, but to hurry her off. It happened too fast. A pull. A loss of balance. A child who couldn't correct herself in time. Sarah fell awkwardly, not from height, but from force and panic. She didn't scream. She went very, very quiet. That silence was worse than any cry. I ran to her. "Sarah, talk to me." She looked at me with wide eyes. "Daddy, my arms feel heavy." She tried to lift them. She couldn't. Karen stepped back immediately. "I didn't do anything," she said. She fell on her own. People stared. A mother gasped. A father pulled out his phone. Karen's voice grew louder. "This is why disabled children need supervision at all times." That sentence landed like a slap. I asked someone to call for medical help. Karen interrupted. "There's no need for emergency services. We'll file an incident report." Incident report. My daughter was lying on the ground, shaking, unable to move her arms, and she wanted paperwork. I ignored her. I held Sarah and told her to breathe with me. 1, 2, 3. She tried to be brave. "Am I in trouble?" she asked. That question broke me. Paramedics assessed her carefully. They didn't rush. They didn't panic. But their eyes changed when they checked her arms. "We need to take her in," one said quietly. Karen scoffed. "This is excessive." The paramedic looked at her and replied flatly. "No, ma'am. What's excessive is interfering with a child's safety." Karen said nothing after that. At the hospital, tests were run. Doctors spoke in low tones. Nurses moved gently. Finally, the physician came back. "Your daughter has sustained serious injuries to both arms," he said. They're consistent with an uncontrolled fall following forceful movement. Forceful movement. Not an accident. Not clumsiness. Force. Sarah was placed in supportive casts. She looked so small in the hospital bed. "I'm sorry," she whispered to me. "I didn't mean to make trouble." I leaned in close. "You didn't," I said. "You survived it." While we were still at the hospital, my phone buzzed. An email. Subject line: Playground Incident HOA Review Pending. They hadn't asked how she was. They hadn't apologized. They wanted control. They wanted silence. Then something unexpected happened. My phone started ringing. A parent who filmed the moment. A teenager who saw Karen grab the swing. A groundskeeper who'd warned Karen before about confronting kids. Everyone said the same thing. This went too far. And they were ready to speak. That night, as my daughter slept, I sat beside her bed. Her arms immobilized. Her face peaceful only because of exhaustion. I didn't feel rage. I felt clarity. This wasn't an HOA issue anymore. This was a criminal matter involving a disabled child. And this time, the system wasn't going to look away. The hospital room smelled like antiseptic and quiet fear. Sarah slept under thin blankets, both arms secured in soft casts, her fingers twitching occasionally as if her body was still trying to understand what had happened. I hadn't slept at all. Because while my daughter rested, the story outside that room was already being rewritten, and not in our favor. By morning, messages flooded the community group chat. Child fell due to lack of supervision. HOA followed protocol. Playground use violated posted rules. They were laying the groundwork. Carefully. Strategically. Coldly. Karen hadn't checked on Sarah. She hadn't reached out to us. Instead, she was busy protecting herself. The orthopedic specialist arrived mid-morning. He reviewed scans, examined swelling, and spoke gently to Sarah. Then he turned to me. "These injuries are not consistent with a simple stumble," he said. "They show signs of abrupt force applied during movement." I asked him to repeat it. He did, slowly. And he documented it. That report changed everything. With the medical findings in hand, I contacted Child Protective Services, not as an accusation, but as a safeguard. They escalated it immediately. Because when a disabled child is injured due to an adult's actions, procedure demands scrutiny. The playground was sealed for review. The HOA was notified. Karen was notified. She did not respond calmly. Her emails became aggressive. She demanded footage be handled internally. She accused witnesses of exaggeration. She warned parents about legal consequences for false claims. That threat backfired. People don't like being silenced, especially when they've watched a child get hurt. By the afternoon, I had 3 videos. Different angles. Different phones. Same moment. Karen stepping in. Karen grabbing the swing. Karen pulling Sarah off too fast. You could hear someone shout, "Hey, be careful." Then the fall. Then silence. No dramatic music. No editing. Just truth. I forwarded the videos and the medical report to the local district attorney's office. Within hours, an investigator called me back. His tone was different from the HOA's. Measured. Serious. "Sir," he said, "this is no longer a civil matter." That sentence carried weight. That evening, the HOA board requested an emergency meeting. Not with parents. With lawyers. Karen was reportedly advised not to attend. That was new. The woman who thrived on confrontation was suddenly absent. Parents came forward to give sworn statements. So did a playground supervisor, a maintenance worker, a high school student volunteering nearby. Their accounts aligned. Karen had a history of targeting disabled individuals, escalating confrontations, ignoring safety boundaries. Patterns began to emerge. Patterns prosecutors notice. A child advocate interviewed Sarah. Not with pressure. With crayons and patience. Sarah explained in her own words. She pulled me because she was mad. I got scared. Then I fell. No coaching. No drama. Just honesty. That statement was recorded and preserved. They offered mediation. Then a settlement. Then silence in exchange for compensation. I declined every offer. Not because I wanted punishment. Because I wanted protection. For my daughter. For other children. 2 days later, the investigator called again. We are preparing charges related to reckless endangerment of a minor, he said. Possibly aggravated due to disability status. I closed my eyes. Not in relief. In resolve. Karen was instructed not to contact anyone involved. She was removed from all HOA duties pending investigation. Her authority, once loud and unchecked, vanished overnight. Neighbors who once avoided her now spoke freely. Stories surfaced. Old complaints resurfaced. The image she'd built collapsed under its own weight. That night, Sarah asked me quietly. Will she do it again to someone else? I squeezed her hand gently, careful of the cast. No, I said. Not if I can help it. And for the first time since the playground, she smiled. The courthouse didn't look dramatic from the outside. No flashing lights. No shouting crowds. Just a plain building where truth has nowhere to hide. And that morning, Karen walked into it without her clipboard, without her confidence, and without the authority she once abused so freely. The district attorney spoke first. His words were careful but firm. Based on medical evidence, video documentation, and sworn witness statements, the state is filing criminal charges related to reckless endangerment and unlawful force against a disabled minor. No embellishment. No emotion. Just facts. Karen stared straight ahead. For the first time since this began, she wasn't interrupting. The charges were read aloud. Reckless endangerment of a child. Aggravated conduct due to disability status. Abuse of authority. Interference with emergency response. Each one landed heavier than the last. The judge looked directly at her. These are serious allegations, he said. Do you understand the charges against you? Karen nodded. She didn't speak. The HOA released a public statement that same afternoon. They used words like deeply concerning, individual action, no longer affiliated. The same organization that once empowered her now acted as if she'd never existed. Residents noticed. And they remembered. Parents who once stayed quiet began sharing their stories. Disabled residents spoke about being targeted. Children talked about being scared of the playground. Emails surfaced showing ignored complaints. The narrative shifted. This wasn't one bad moment. This was a pattern finally exposed. Karen's attorney tried to argue intent. She didn't mean harm. The prosecutor responded calmly. Intent does not excuse reckless force, especially against a child who cannot protect herself. The judge agreed. Bail conditions were set. Restrictions imposed. Karen was ordered to have no contact with minors during the case. That alone spoke volumes. Sarah didn't testify in court. She didn't have to. Her recorded statement, gentle, clear, honest, was enough. The child advocate told us later. She told the truth without fear. That's powerful. Sarah didn't see herself as brave. She just said, I told what happened. Weeks later, after the news had spread and the charges were public, we returned to the playground. Not to relive anything, but to reclaim it. New signs were posted. Inclusive use encouraged. Zero tolerance for harassment. Emergency protocols clearly outlined. Sarah watched other children swing and laugh. Then she looked at me. "Can I try again?" she asked. I nodded. Slowly. Carefully. She smiled. Justice didn't look like revenge. It looked like accountability, protection, change. Karen would face the legal system. The HOA would face reform. And my daughter, my brave, resilient daughter, would grow up knowing that her safety mattered. This story was never about an HOA. It was about what happens when unchecked authority meets a vulnerable child. And what happens when parents, witnesses, and truth refuse to stay silent. If you take anything from this story, let it be this. Rules are not more important than people. Power is not more important than compassion. And no title excuses harming a child.